starting now. It's a 181 Friday group meeting. The today's speaker is Mr. Pragyan Pradip Sharma. He's a best friend. He's a very prominent lawyer and is thorough in the subject. The topic is copyright law in India, contentious issues and emerging trends. I request Rahul Agarwal to say a few words about Pragyan ji. Please, Rahul. Please,
Yes. Mr. Pragyan Pradip Sharma is an independent legal counsel and concentrates his litigation practice in resolution of complex disputes before the Supreme Court of India, Delhi High Court, High Courts of different states of India, tribunals and arbitral institutions. During Mr. Sharma's extensive litigation practice spanning over 25 years, he had the occasion to deal with the various aspects of copyright law and has represented various production houses including UTV, Fox Studios, Viacom, various directors, music companies which includes Saregamapa, Sony, Tips and venues in several high-profile copyright litigation and is considered as an expert in the area of copyright. Mr. Sharma also assisted the Justice S.N. Fukan Commission of Inquiry, which is known as Telka Commission, as junior counsel of the Commission and assisted Justice R.S. Pathak, the former Chief Justice of India, as the counsel for the Commission, which is known as Justice R.S. Pathak Commission of Inquiry, inquiring into the oil for food scam based on the report of the Boker Commission.
Thank you so much. Very nice of you.
Thank you, Rahul. Just now you
That is quite an innovation actually. This is so we are speaking of innovation, a subject of innovation, and we have innovation right in with us. So first of all, I would really like to thank G.Seshagiri for having offered me opportunity of coming and speaking in this esteemed group. I in fact was quite threatened after seeing the entirety of the various names so well respected and legends in the bar. So I graciously accepted to speak on this topic. I believe Justice Vishwanathan sir had said that we should diversify and also have topics of emerging areas, and copyright is one such area, and therefore I really thank you. So I can just quickly start. So copyright actually is a part of intellectual properties laws, as everybody probably knows, and it is called the Cinderella law. Why so? Because copyright law before the digital revolution that has now taken place throughout the world was not in prominence at all. What was in prominence was trademark and patents. So mostly lawyers knew about patents and trademarks, but very few people knew about copyright. But with the digital revolution, content, which is what is recorded, what you are recording now here probably, has become of a huge value, and there is people saw an economic value to that. So with the economic value to it, obviously the clamor for it started increasing, and so you have lawyers exclusively practicing in the area of copyright and digital media, students wanting to study copyright law. So the whole thing, whole plethora of an separate industry in copyright has started evolving. So let us first understand, so today copyright is actually a very vast area. I've tried to narrow it down substantially, and I was discussing with Seshu sir, probably we'll need about 2 sessions for something like this. 1 hour is not going to be sufficient. So what we will do today, I will just give a broad overview of the Copyright Act and some very interesting aspects of it, and then maybe later I can go in depth of various issues and then elaborate more on those. So how did our Copyright Act come into play? So like most of the acts, our Copyright Act is also based and founded on the 1911 Copyright Act of the UK, because India was obviously under the UK. Then after 1911 Act, India, the Indian, there was an Indian Copyright Act in 1914. And then we had, after independence, the 1957 Copyright Act. And immediately thereafter, 58 rules, copyright rules were also enacted. So broadly, this is the structure, and Copyright Act has gone several amendments also, primarily because India had to comply with various regulations under the GATT and TRIPS. So our laws have to be obviously be compliant with the international laws based on the agreement that India has entered into under the TRIPS agreement. So to align with those regulations, we had to fine tune the Copyright Act, and therefore amendments came in 1994 and a major amendment in 2012. I'll come into those later. 2012 actually made huge and very far-reaching amendments. Now, what do we understand, first of all, going to the root of the issue, what do we understand by copyright? So, copyright is, as I said, is an economic right. But what does it entail? It says that if you have this particular content that we are recording now, who has the copyright of it? Now, suppose, assuming the Friday group as a whole has a copyright over this audio, or rather the video, now it is the Friday group only who has the right to authorize others to use it in some form or the other, either view it or disseminate it to public or download it. So since the Friday groups uploads it in the so-and-so, it is giving the entire world an opportunity to go and have a look. But the owner of that particular content or this particular copyright will have a right not to let anybody else use it. So that is his right under the law. It is an economic right. And there are judgments also to say in the Supreme Court, and I'll come to those later, that copyright today or intellectual property right today is akin to a right to property which is there under 309. Okay, so it is given that kind of a status to the copyright or trademark. So if you want a citation, that is the judgment of ENIL versus in Super Cassettes 2008 13 SEC, I think, page 30, that deals with this particular issue where copyright and trademark have been given the status of a right to property. So therefore, if I use this content without a license, then that is called something called an infringement. I'll come to that later. But that is what an infringement. So you cannot use anybody else's property without a consent, right? So that is basically it. Now, where is copyright? Now, if I have an idea to do a particular thing, is there a copyright in that? The answer is definitely a no. There is Supreme Court in the Eastern Book Company matter has held that there is no copyright in an idea. But what you do with an idea is the copyright. You know, suppose there is an idea, whole plot of a movie. Okay, that is an idea. Based on that, when you go ahead and make the movie, that movie is a cinematograph and it is a copyright. Now, so we have understood now what is a copyright. Now, where does copyright subsist? Now, copyright subsists in something that is created originally, like it can be a book, it can be a play, it can be an art. The painting right in front of us is a pure work of copyright. So these are the original copyrights. But what the Copyright Act also specifies, certain works which are not directly copyright is also been deemed to be a copyright, which is basically a derivative right. So let's take two works that the Copyright Act has said to be a derivative work is one is a cinematograph, that is a movie, and secondly a sound recording. Okay. Now why is a cinematograph or a sound recording a derivative right? Because let's take a cinematograph for a time being. What is a cinematograph? Cinematograph is a combination of photography by the cinematographer. Then there are songs. Now what is there in a song? In a song, that is a sound recording. What is there in a song? Sound, there is a dhun. Okay, dhun as is the composition. There is the lyrics which is built in to that. These are all original works. So all the original works are bounded together and then there forms a derivative work which is a sound recording or a cinematograph work. Now, an original work is obviously entitled to protection under the Copyright Act. There is no doubt about that, right? But the question is, would a derivative work also have a similar protection? Okay, the Copyright Act does give that benefit to a derivative work also, provided the original work, the derivative work has got a completely a new identity or an identity which is different from the original work. So the best case or the leading case, rather no discussion on copyright law cannot, any discussion on copyright law cannot start without the case of R.G. Anand versus Deluxe Films. This was relating to a play called Hum Hindustani. Now the play was basically then made into a movie called New Delhi, right? So R.G. Anand, who was the author of the play, said that look, the whole plot and scheme that was there have been translated into the movie, so how can he do it without taking a license from me? So the Supreme Court said, look, that was an idea. What the movie has made, what the movie that has been made is a completely a new kind of a thing that has no relation to, direct relation to the plot in the play. So therefore a new work has come into play, and therefore that cinematograph, which is, it becomes or takes the shape of an original work, and therefore it is entitled to copyright protection, and did not grant any injunction and dismissed the suit filed by R.G. Anand. So this is one of the leading cases. So how do you distinguish, or how do you distinguish as to whether the new work that is being created is a infringement, or is it a original work? So the Supreme Court in this judgment itself laid down certain test. Now what was the test? Test is, suppose I as an individual, it is called the viewer's or the reader's test. Suppose you read two books, you read this particular journal and you read a similar other book. Why, after reading the two, do you think, oh, this book is exactly the same, I read this whole thing in this book? If you have that impression, then it is a copy, or rather there is an infringement of the copyright of the earlier publication. But if after reading it, the reader or the viewer feels, no, there is a distinction, okay, then it is the original work. That is the test the Supreme Court has laid down. Now, why the original, whether it is an original work or it is not an original work, it is important, is also because today the entirety of the world is going to be working on data. Okay, data has become, again, like content is a king, data is also the king. So a lot of freebies are given to us today by various companies just to collect our phone numbers, etc. Right? So data is becoming very, very important. So there is suppose one company has a data, and then he has compiled that data, and that data then can be used by somebody else. So the first company who has that compilation can always say, look, you can't do anything with the information or data that is available with me. So what is the test? On what basis will the new person be able to use that data to create something new or create something original? So in that context, concept of originality has become very important, and it's a very emerging trend actually, because everything is developing. Copyright is a very nascent kind of a law. It's developing every day, and more so because it's connected to technology. So therefore every day there are changes, there are new pronouncements coming, the law is developing. So copyright, you cannot put that in a straitjacket, although the act is there, the letter of the law is there. So it is an expanding, in my view, it is a very expanding kind of and a dynamic kind of a law. So how do you test, what is the test of originality, whether the new work is an original copy or not? So the UK law said that if the new work is a sweat of the brow, suppose you have worked hard on the new copy and not directly taking it. So sweat of the brow is when you work hard, you get the sweat. So it's called the sweat of the brow. So if that kind of an effort is put in, then it is an original work. That concept is similar to what was there in the US called mediocrum of creativity. It's almost the same concept. So if you want to note down, the sweat of the brow concept was laid down in a case of the House of Lords in Ladbroke versus William Hill. It's a 1964 judgment, a landmark judgment in the area of copyright. But what is very important, and especially a matter of great pride as far as India is concerned, that in the EBC judgment, Eastern Book Company judgment, which is again a landmark, what happened, Indian courts have laid down a test which goes far ahead of the sweat of the brow concept. It says that the original work, the derivative work, or rather the new work, if it is not sufficient if the new work is only a sweat of the brow. Something more is required. Okay, so I'm sure everybody knows the EBC judgment. What happened? Eastern Book Company publishes all this SEC online and everything, you know. So the question was whether there is a copyright on the judgments pronounced by the Supreme Court of India. And when the publication is done, whether the judgments per se, SEC will have a copyright over that. So I think this was a dispute with Scale and the others. So this is exactly what happened. So the Supreme Court held that no, there is no copyright as far as judgments is concerned, because judgments are something which is in the public domain. So there is no copyright in it. But what the Supreme Court said, that the copywriting, whatever you do, the edits that you do, you might have certain copyrights in that. Say for example, the manner in which paragraph numbering is done in a judgment. Or if you see SCC, sometimes there is an editorial comment or editorial opinion. Okay, and they say whether it's a concurring judgment, dissenting judgment. In the copies that we get from the Supreme Court website, you don't have a concurring judgment. There are two separate sheets of judgment by two judges. When they write a dissenting, concurring, okay. So in those things there is a copyright. There is also a copyright in the head note, and rather the footnote, the head note, and the summary of the judgment. There are copyrights, but there cannot be a copyright as far as the judgments per se is concerned, and therefore it completely negated the case as far as Eastern Book Company is concerned. But in the process, it laid down a law which is a complete, it went away from the US and the UK law, and more or less relied on the Canadian kind of a version of law, which said that along with sweat of the brow, you also need to have skill and judgment put in that particular work. So sweat of the brow plus skill and judgment. If all these things are combined, then only a original work would be created. If not, then the work is not original, and therefore it will not have protection under the Copyright Act. So, as I said, going forward, India has tremendous population, as we all know, so we have a huge database. So anything that any app, any application, anything that is done going forward will have to have this test, which is a well-respected and now an established kind of a precedent, which was again Rameshwar Prasad judgment, which is the photocopier judgment, as you all know. So in that also it has been relied on. So it is this particular law and this particular framework is now come to stand, more or less. So that is as far as the original work is concerned. Now copyright also has something called, now who's the owner of a copyright? The owner of the copyright is obviously the person who makes that particular painting. So there are various paintings here, so I'll give that particular example. Now, but suppose the Bar Association actually engages an artist and says that, okay, on behalf of the Bar Association of Supreme Court, you kindly make a portrait of an X person. In that case, the Copyright Act section 17 says the owner will be the original, he'll be the author or he'll be the main artist. He'll be known as the author under the Copyright Act. But the owner will be the Supreme Court Bar Association. Why? Because the Copyright Act lays down a distinction while determining ownership between a contract of service and a contract for service. So in a contract of service, suppose he's done it under employment, then obviously Supreme Court Bar Association is the owner. Suppose one of the people who help out with getting the books, they would have drawn something. They are employees of the bar. So obviously Supreme Court. But if an independent person does it, then what? So if it is a commissioned work, contract for service, then the Bar Association will be this thing, because the author or the artist has got remuneration for that particular work and he was commissioned for it. But there are certain cases, this is more so, we see this in the music industry. There is only one person who says that I am not giving my copyright to anybody, that is A.R. Rahman. Rest everybody gives up their copyright. So A.R. Rahman says, I am not doing any contract for service. If I have to do, this is going to be my work and I am going to take the royalties out of it. There is no assignment as far as this. So he'll acknowledge me as the composer and I will do it. But he is able to do that. See, finally it is, as I said, it is an economic right. So the doctrine of laissez-faire, economic, all that will definitely be there. So it is basically a question of demand and supply. Sachin Tendulkar can claim whatever. He is the most premier kind of a thing, premier kind of a sportsman. Similarly, Rahman Saab is the most renowned composer. So he can ask for his pie. So that is the thing. Now, why I say 2012 amendment was very important is that there was a lot of exploitation as far as various authors and composers were there by the music companies, and the cinematographers or the producers of the movies used to exploit the various artists, etc. And in fact, I was representing for a long time the producers and the music companies in these litigations, and I personally I strongly support the amendment that has come in. What it did to protect the artist or the creators of content, which are the most respected persons because they are the ones who are creating a whole community. What they did is that they said that if you assign more than 50% of the royalty that you are to earn, then that contract is void and non-est in law. So why was this important? So what would happen is that the director or the producer will catch hold of a singer. He says, you sign on this, you take $500 or $2,000 and assign all rights in the song forever to me. Okay? So that song becomes a huge hit. And even today, a song which is there of 72 say or 73 when I was born is even played in the radio today. That song even today generates revenue. So who gets the money? It is the producer or the music company that keeps on getting money every year on year from that. Okay? And what does the original person who actually made that dhun, okay, get? Nothing. So therefore, to protect that, in order to make the law more favorable to the artist and the creative community, the legislature in the 2012 Act made this kind of an amendment saying that you can assign it, but even though you have assigned it, you are still entitled to 50% of the royalty. There is a huge controversy going on as to whether that amendment would be prospective, retrospective or retroactive. Okay, so the songs were written prior to 2000, assuming a song is written prior to 2012. Okay, now the copyright hence was created earlier, but the song is being played today. So if the song is played today, will he still get a copyright for that, or will he still get a royalty for that? Okay, that is test time will only, the pronouncements have not yet come. My personal view is, it is retroactive. It's neither retrospective nor prospective, but retroactive. Why? If the exploitation is happening today or after 2012, the royalty, of course, 50% of the royalty should go to the author composer. So that is my view, or the director, as the case may be. So we have covered these two main areas. Then we have also covered assignment. So the other concept is, what is the term of a copyright, right? So this one more aspect. Now, very important, especially suppose somebody of us wants to draft an assignment deed. There are some of 2-3 things that are important. Assignment deed has to be in writing always. Assignment deed has to have a particular term. Okay? If there is no term, however, the law now specifies under the 2012 amendment that it will be for a period of 5 years. Then it has to put a territory. So for example, since it's a property, it's like a lease. Suppose you have a whole building, you can lease one part of it, first floor, and not the second floor. Now, putting that on maybe a musical composition, a song. Now, what are the various rights in a song? A song has lyrical right, musical right, lyrical as is the words of the song, the musical right as in the dhun of the song, and the sound recording, which is the CD, right, or the music cassettes as it was earlier. So one person can be given the musical right, the other person can be given the literary right, and the third person the sound recording, right? But the owner can also decide, no, I will give it to one particular person, that is the music company. So be it. It is the owner who will decide. So an assignment can be broken up into various fragments also, various territories also. I will give this assignment only for Delhi. Okay. So this is permutation, various permutation combinations would be there. Now coming to the term now. The term is, for literary, dramatic, music, artistic work, it is the lifespan of the creator, that is the author, and thereafter 60 years. Okay. But for a sound recording, but for a derivative work, that is a sound recording or a cinematograph, it is 60 years from the date of the actual publication of it, right? Now another interesting issue is the issue of licensing. Now I am the owner. Now what is copyright? What does copyright do actually? Copyright technically balances the rights of the owner and the rights of the user, basically, or the public at large. Now I like music and I want to hear music. The owner can say, look, I won't give it to you. Okay. Now can he do that is the question. Now the answer to that, if he is put it out on the general public, he then can't say, look, now I am stopping it. Because he can't give the carrot to the public and then say, no, I am not giving it. I will charge a lakh of rupees, which he was charging, say, 10,000 rupees. Now the value has gone up. I will charge a lakh of rupees. Otherwise, this content is not there for you. Okay. This very matter came up before the Supreme Court from Delhi. There was an appeal from the Delhi High Court as well as the Bombay High Court. This matter came up before the Supreme Court. A bench of Justice Sinha said that no, once music or any copyrighted content is available, or you made it available to the public, you can't say, I will give it to X, I will give it to Y. It has to be uniformly given. Okay. And who will fix the price? There is a mechanism provided under the Act that you make an application before the Copyright Board. Thereafter it became the IPAB in the amendment. Now you have to make an application before the High Court. And then they will decide what the tariff should be. I will come to that. So that is what is licensing broadly, that for using the content, this content, I probably have to use the permission of the Friday group, or probably from Sheshu sir, because he more or less is the sutradhar of it, as always. So, but I have to take, that is called, when he allows me to use that, it is a license that he gives. And that licensing, when we do it inter se, after a discussion, is called a voluntary licensing. So, a voluntary licensing might not happen sometimes because Seshu sir might say, I am not going to give it to you. Or He might say, he might quote an atrocious price for it. Then what is the remedy for a user to use that content? This is more important because you might have seen in a movie or in some serial they put in some song or whatever it is. So the Saregama might say, no, I am not giving this song. So Saregama can be restrained, or that song actually can be taken from Saregama under law, because you cannot deprive the public from the enjoying that particular content. So there are two ways. One is called compulsory licensing and other is called statutory licensing. Now compulsory licensing is basically for broadcasting and all, which is you have to compulsory license. A stronger mechanism is provided under 2012 Act, whereby the statute itself mandates that you have to give the content and make it available to everybody. Now this is technically a fallback of what Justice Sinha had said, that it should be for everybody, etc. So the law got amended based on what the judgment of the Supreme Court was. Now, how do you get a statutory license? There is a process specified in the rules. You apply and then you particularly pay a fee and then you take the license. Now, one of the tests was there is a huge procedure followed in Rule 29, which is quite cumbersome. The music companies and the corporate other movie companies came before the Supreme Court. A bench of Justice Chandrachud has held, look, you are entitled to a statutory licensing and you are entitled to content, but the process which is there under the Copyright Act, under Rule 29 of the Copyright Act, that cannot be bypassed. Okay. There has to be a procedure that has to be followed. It cannot be unilateral and arbitrary, that you just take the song and start using it. It cannot be. Okay. That process has to be followed and complied with. Right. Now that judgment, if somebody is interested in citations, is 2022 1 SCC, again a very important judgment in the context of modern day, because people are using content on a day-to-day basis, and the trend is growing. So how does licensing happen? Now, is it possible? How many music companies or how many producers are there? Huge number. Now suppose, let's take a situation of a restaurant. When you go to a restaurant, you hear music. So the restaurant owner is not he wants to play, people want to hear songs of different songs which is owned by different people. So can he go to each person and then ask, okay, give me a license, give me a license? So that is not his business. His business is to run a restaurant. So therefore what the law provided, that all of you should come and form a copyright society, which will be an organization or rather a single window to issue licenses, and that copyright society will be only involved in issuing licenses. For sound recording, there is something called phonographic performance. There is something called IPRS for musical and literary rights, authors and composers. So the idea or the concept was that there should be only one copyright society for one specific right. But the problem that has happened today, and if you go and talk to a restaurant owner, you will always know that he is irritated, he is stressed out. I don't know where to go, whom to ask. Because today there are so many agencies that are collecting license fee that he doesn't know what to do. So therefore, that is something again, the jurisprudence with regard to that is to develop, because the Act specifically says, this is section 33, says that it starts with a non-obstante clause saying that no person shall issue a license without being registered as a copyright society, right? So therefore, and it says there can be only one copyright society for one particular work, right? So that is what it is as far as licensing is concerned, copyright society is concerned. Now, copyright society technically steps into the shoes of the author, composer, etc. Now, another very important person in the whole scheme of creating content is the performer, right? Now performer is Kishore Kumar, performer is Devanand, okay. So these are all performers, but performers per se never had any rights whatsoever. Can you imagine? Performers for the first time had their name imprinted in the Copyright Act in 1994 only after the Rome Convention. Before that, there was performers had nothing to do. Okay. Now even in 94, they had no right whatsoever. It says that performer will have a right. Okay. And that right was only there for live performances. Suppose you do a live concert. So your live concert, for the live concert only you will have a copyright. Rest of the songs where you perform and your song is digitally recorded and made into a cassette or this thing, you have no right. Right? And that is another change that the Copyright Act 2012 did. What it did is that if you want to make another recording or another, reproduction of the song or the movie, then you'll have to still pay me some 50% or part of that. But the problem, there is a slight problem. Now the Copyright Act says that the performer's work will be only for live performances. But the copyright rules of 2013, which followed the 2012 amendment, says that even a recording in a studio, you are entitled to royalty even for a recording in the studio. So the problem that the performers are facing today is that there is a clear dichotomy between the act and the rule. So, and the law is very clear that if there is a dichotomy, then the rule or act obviously prevails. So, due to that, instead of bringing in a legislation, it was actually the Commerce Ministry stepped in, and they have now the whole industry have an understanding, rather an MOU have been executed, where some portion of the royalty, in spite of the act being the way it is, will be going. So this is not in the act, but this is an arrangement that has been built up to actually promote singers like, who actually need the money the most. There are very few Lata Mangeshkars, there are very few Asha Mangeshkar or whatever, Asha Bhosle. But there are various small singers who are 5-song wonders, but those songs are very popular. But the sad part is they are completely living in penury. They have no right, they don't even have a building. You will be amazed to know that Hassan Kamal, he was a great, not Kamal Hassan, the actor, Hassan Kamal. There used to be how many of you? Nobody would have heard of him, and he actually has written such amazing works, and the poor fellow doesn't have any money. But the music composer or the music producer or the cinematographer or the producer would have made huge tons of money out of that. So therefore, this amendment that has been done will go a long way in giving back the due that the author composers are entitled. There is another very important right. It's called the author's right or the special right or the moral right under the Copyright Act. There are two rights. I will not go into the details of it. This is a whole topic, very interesting again. Now, there are two rights emanating out of that. One, that is called the right of paternity and the right of integrity. Now, what is the right of paternity? Right of paternity is to call the child my own, right? That this work, I have a right to say that painting is mine, right? Now, suppose an artist slightly makes a different portrait of the gentleman and creates a different work. Okay, that will be would that be an original work? If does it from a picture, etc., it will be a new work. But if this painting itself is distorted, so the person is clean shaven here, if there is a mustache that is made out, or if there is a horn that is made out, so he can, that is the right of integrity that the author has. He can claim an injunction, say this is the way I conceived my work, you cannot change that work. Now the leading case in this is the case of Amarnath Sehgal. Amarnath Sehgal actually had the house right opposite my office in Jangpura. So he was a great sculptor. So he did a lot of things. He kept Vigyan Bhavan, if anybody is gone, right in the beginning. earlier there used to be a huge sculpture. Now after some time, and he had given it for a 1 rupee to the government for, so that his name is also displayed prominently. So what happened, that the whole structure or the whole installation was removed and kept in this thing in the godown. So he filed the suit in the Delhi High Court, said, "Boss, this is not the reason why I gave the permission or created this. You have completely distorted and mutilated my mural, and I am entitled to compensation." So Delhi High Court said, "Yes, you are entitled to it," and went ahead and granted an injunction and restored the whole thing out. Then there are other things. Other Manu Bhandari's matter is there, where the movie was Samay Ki Dhara, right? And the author initially was that was an adaptation of the novel called Aapka Banti, right? So what happened? The movie Samay Ki Dhara copied, or rather took inspiration from the basic plot, but the whole story was depicted in a different way. So the Delhi High Court again said, no, since the whole thing was different, therefore you have no copyright. Okay, this is a new work, new created work, original work has come to be created, therefore you can't get an injunction. But it said at the same time that the ending that was there, the climax in the movie and this thing was there, it is the same. So therefore, to that extent, the gorier part or the criminal part, the bloodshed, etc., which was there, that has to be removed. So that court has that power. Now suppose there is a violation, your rights have been violated, what do you do? What is the right given under the Copyright Act to protect it? So section 51 says that in case there is somebody takes a thing without a license, then what is your remedy? Your remedy is a suit for infringement. In a suit for infringement, there is something called fair dealing, right? Or a fair use. If there is fair use, section 52 prescribes an exemption to it. There are other things. For example, if you want to use a sound recording for a marriage or for a religious purpose, the Act specifically enumerates about 20-25 odd exceptions as to when a thing is not an infringement. But primary of all of this is the doctrine of fair use or fair dealing. Now, the leading case, the most important case, as I mentioned here, is the case of University of Oxford versus Narendra Publishing House. I think everybody knows this. This is what we know as the key books or the Dukis, which we all used and passed hopefully our law exams based on that. So the question was, and after the Dukis you see a number of questions that are put out, right? So what the Supreme Court said, or rather this was the Delhi High Court, what the Delhi High Court said, now what does a Duki do? The guidebooks, we will have Takwani's CPC, we'll have Mullah's CPC, etc. So it combines all of that, takes out the masala and puts it in about 10 pages, the entire chapter of that book, right? And after the book, based on various questions that has come from various universities, we'll have a set of 20 questions and maybe make answers of that also, So what the Supreme Court has, Delhi High Court held, that look, as far as the chapters or the reworking of the chapters that you have made based on whatever you have copied from different books, you will not have a copyright over that, right? But as far as the questions are concerned, you will have a right, because those are your original questions, right? So that they said based on basically a fair dealing, etc. The other case was the Rameshwar photocopy case, again a very important case. Now if you see, if you go to Bear Sarai, you will find all the IS aspirants there. Why? Because all the notes of the IS aspirants would be available there, photocopied over there, right? So this Oxford University Press again filed a suit for injunction before the Delhi High Court, saying that look, this is a clear case of infringement. All my books, etc., have been copied, and created into dookies, etc. There also the Delhi High Court has stepped in interestingly and has said that look, again that is a fair use, because there is one chapter from here, one chapter from there, so therefore there is no violation of copyright. Although I have a slight difference of view as far as that is concerned, because certain chapters are direct copies, para by para, sentence by sentence, of the works that are copyrighted by University of Oxford. So obviously an injunction was mandated, but I'm sure that the court also obviously is humane, you know, so they got swayed away by the fact that the dookies are made basically for the students, etc. So basically that created a that soft corner in the mind of the court. Now what do we do? Suppose somebody blatantly goes ahead and you obviously can file a suit for injunction. But then injunction, again, the whole test laid down in Gujarat bottling prima facie case, all of that, balance of convenience, irreparable loss, all that will come in. But besides that, what is happening primarily in copyright is that you find today a slight difficulty, in the sense that now suppose there is a website which is putting out illegal content. I don't know how many of you know a site called songs.pk, which had all all songs, all the songs, probably Hindi songs used to be there. The whole site was operating out of Pakistan. Now, and in fact I was also instrumental as a part of that. We filed an injunction suit before the Calcutta High Court, trying to stop songs.pk from actually going ahead and permitting people to download those songs. We got an injunction. So after 2 days, we see another website and we said that kindly stop domain name songs.pk. So after a week, my clients came back to me again and said, sir, there is another website called songs.pk1. Okay, and again those songs were there. Now what do? So we had to file a suit again, right? So, and 2, 3, 4, 5 started happening. So you have to take an injunction every time. So a new concept has developed in copyright law called dynamic injunction. Now what is a dynamic injunction? And it actually emanated out of a judgment in Singapore. So what happens in a dynamic injunction? Like a John Doe order, you get an order from the court saying that any site which has this kind of content, the injunction is there for the granted. So you don't have to make an application to the court per se and then get an order and then execute that order. All you need to do is to make an application to the registrar, and the registrar at that very moment will issue an order, and that has got the same sanctity as a court order. So this is a very interesting development that has happened as far as copyright jurisprudence is concerned, in order to make sure that injunction orders, there is something that comes out of an injunction order. Otherwise the injunction order is just a mere order in the paper itself. So therefore, in order to convert that into something more real, the court has evolved, or rather, as I said, copyright has to evolve with time, evolve with technology. So the Delhi High Court actually has stepped up and evolved this kind of a law based on the Singapore High Court order, and this is working phenomenally well as far as these various websites are concerned. There is another very interesting issue, emerging issue, which is that there are various rogue websites. Now, in some websites, there is certain amount of work that is copyright violations and some amount of work that is original work. Now the question is, for that, will you stop the entirety of the website, right? So Delhi High Court and Bombay High Court, there are two schools of thought, that if there is an injunction, the entire website can be blocked. Okay, but the Bombay High Court seems to have said, no, if there is an injunction, then only that particular content needs to be removed. Although that is very difficult. Suppose the website is put up somewhere outside India, how do you execute that? So these issues are various challenging issues that will come up. Okay, and these are issues that needs to be gone into in much more detail, and I would request, sir, if we can have another round subsequently. We will go into all this. Another very interesting aspect that I want to get into probably on the next lecture is the issue with regarding to personality rights and privacy rights. For example, everybody would have heard about the Amitabh Bachchan case, and thereafter, so where Amitabh Bachchan's face was used in various t-shirts, in various websites. The question is, does he have a right to injunct others from using his face because he is a personality? Okay. Whether Article 14, freedom of speech and expression, Article 19 would come into play in such kind of a thing. This is a very developing area. Okay, and recently Justice Hari Shankar has passed an order in this line. There is an order by Justice Amit Bansal. So I would love to speak about personality rights and privacy rights some other time. These are again areas which are growing out of the Copyright Act per se, because no other legislation, unlike UK, India doesn't have a specific statute governing personality rights and privacy rights. Okay, I look forward to that. I would be very happy for questions.
Thank you very much, Pragyan. Very enlightening. It's a very thought-provoking.
Sorry, I
so many
exceeded
things.
that time.
No, it's all right. It's all. We love to hear the part 2 also, as and
sure,
we get
thank you.
an opportunity
Sure.
to hear in a detail, further details. When we'll inform you as and
It
when.
will be a
it's
pleasure,
when
sir. It
we-
will be a pleasure.
So much of, even including Friday group itself, video uploading, you have given a great example.
Yes.
What more it must have, very pleasure to hear.
Thank you, sir.
So
Thank you, sir.
now, any questions, please, you can ask, please. Yeah, please.
Yeah, thank you.
I have a question.
Yeah.
What is the difference between an artist and
It is actually the same. See, the performer is a performer who technically performs on stage.
Yeah, yeah.
In a lot of times, performer word is normally used for actors or for singers. An artist will also be a painter also.
like, for instance, you earlier said that under the 2012 amendment, performers have now been given.
No problem.
Correct. Of the royalty
Say
rights.
Kishore Kumar show.
Correct.
So Kishore Kumar is a performer.
Right.
So he will now get 50%. Or if he was alive, he would his estate.
Yeah, no, his legal heirs would get it.
Legal heirs are entitled to it.
Yes, of course.
But then later on you were talking about performers.
Mhm.
When you said that under the rules, they are
There is
now
a-
being given something.
I'll just clarify that. Now, if you see the definition of the word performer or a performance, which is there in 2Q of the Act, it says performance is something which is live, right? So when you say live, it means live on stage probably, nothing else. It can't mean anything else. But if you go to see the rules, rule says, especially the explanation to the rules, the new 2013 rule says that a performance inside a studio will also be counted as a performance. Okay, or recording inside a studio will also be counted as a performance. So the definition of performance in the Act and what is contemplated in the rules is different. And had it not been for this agreement between the parties, the performers probably from the studio recordings, they wouldn't get any royalty.
So let's take the example of, say, a singer, songwriter, still alive, recording a song in a studio.
Correct.
So he is the artist in that song,
Right. He's a performer in the song.
but he is the artist also.
Yes, artist also
So
in
he
a
will
way.
get 50% under the Act.
He'll get 50% of the performer's royalty, yes.
Performer's royalty under
Correct.
the Act.
Right.
So basically, artist and performer is the same thing.
Artist and performer, yeah, it is
That's what
probably
I'm
synonymous. But again, again I say, if you go by the strict letter of law, my interpretation of the Act is that he is not entitled to it. Per se, if you go by the Act, he is not entitled to it because the rules cannot override the Act. But he will get today only because of the agreement interested the parties that has happened recently, about 6 months back. But he will still get, divorce the agreement, he will still get royalty for any live performance. If the live performance is being recorded and utilized for commercial benefit, he will be entitled to royalty for that.
Next, yeah, please.
And so this performers right, they also cover those junior artists,
Everybody,
yeah,
everybody.
perform in the background.
Correct. So provided they
Not just
have
the main singer, yeah.
No. Yeah, okay. Very interesting question. Very interesting question. See, the performer, actually you are so right. Even a juggler is a performer, right? Even those people who dance in the background of the main actors are also performers. But unfortunately, the law is not developed to that extent that they get the benefit. It's only the Kishore Kumar who will get the benefit. The side singers who do the chorus who never gets probably the benefit because they go into the sidelines, etc. But if you go to see, the song becomes a hit because of Kishore Kumar and his music, or Lata Mangeshkar, So I don't know, and they get the money for coming and performing here. So coming back to the legal profession, is the seniors who get the actual moolah. The juniors are left, So something like that.
Yeah, any more question? Please
Sir,
continue.
you talked about the artistic right, performing right. Sir, and there is one other field of copyright, which is coding.
Coding,
or
yes.
Program.
Yeah.
And so now artificial intelligence is being developed at
Correct.
a very large
Correct.
level. So would there be any changes because so far this coding comes under the purview of copyright.
Mm-hmm.
Would there be a paradigm shift to patent
No.
for coding?
Coding technically
AI develops.
will so if there is a software
hardware
will come under the Copyright Act.
Yes.
So coding is nothing but
Writing.
something under the Copyright Act because this is a particular program that is written down, you say, right? So the Copyright Act protects that. But what would be interesting is that a lot of codes are being made, a lot of things are being done based on various data that the AI actually builds in. Okay? Now, as I said, therefore I mentioned the judgment of EBC judgment, Eastern Book Company judgment, that lays down the test of originality, right? Whether an AI platform is original or not would be a question in the future. Coding done through an AI, whether it's original. So for that, you have to apply the test laid down in the EBC judgment, that is sweat of the brow plus skill and judgment. If that test is fulfilled, then it will be an original AI work or whatever it is. But you are right, and it's a very interesting domain. The AI will only collate things from different websites and different this thing and create something on its
So
own.
like-
There is technically no sweat of the brow.
Like we have Chat GPT, and so semi-autonomous and autonomous outcomes would be there.
Yeah, that is true, but we'll have to see how that law develops as far as that. Another very interesting concept, another aspect that I forgot to mention is the live proceedings that we see from the Supreme Court. You find people now making feeds out of it, or what is it called, reels out of it, right? So what is the copyright of that? Does the court have a copyright if a judgment is in public domain and there is no copyright in a judgment? Will the Supreme Court live proceedings, will there be a copyright to that? The answer is yes, because the Copyright Act specifically provides for it that the judgments are made in the public domain as a matter of right by the Supreme Court. They can also restrict that right. So what the Delhi High Court has done, Delhi High Court has issued rules and guidelines in 2022 whereby Delhi High Court live proceedings, the copyright is now vested with the Delhi High Court. And any illegal use or any unlicensed use of that in terms of reels or other uses is completely prohibited. The Supreme Court, however, was the first mover in terms of drafting a rule, but it still is a draft stage. It has not actually been made into a final kind of a rule as such, but it is still there. There are probably some complications, I don't know what, but it should be done immediately, because I was speaking to somebody the other day. Today the judge is really, not very forthcoming in saying, so delivery of justice is being affected because of that. He is not able to say a lot of things because he thinks that maybe this will be recorded, that will be recorded, So the rules should come in immediately and strict action should be taken is what my view is.
Yeah, anyone? Please, Geetanjali? Yeah, okay.
If I vaguely remember, section 107 of the Copyright Act,
Correct.
it says that if I am using any video or any part of video for fair use or teaching purposes, then I would be excluded from the purview of Copyright Act. So,
Yes, yes.
So when that is the case, say what happens if I...
Section 52, not 107,
I'm sorry,
52.
52. So under section 52, so what if I use a particular performance which incidentally gets monetized, someone monetized, so will the person, that is the person who uses it, will he be held responsible?
So the test is, suppose the license has been given to you to do it for educational purposes, right? Then you are not entitled to take a license or you are exempt. But if you have officially got it from him free of cost or your license has been given to you without money because it falls within the exemption and you misuse that, right? So you will be liable for both civil and criminal consequences. There is a 2-year punishment for an infringement. Although there is a bill now which is in the parliament, but where the central government is now contemplating of decriminalizing several similar offences like in the Copyright Act. 52 acts are being decriminalized. Okay, so even the criminal provisions of the Copyright Act are being sought to be decriminalized. But to answer your question, yes, both you as well as the person who is using it for commercial gain are liable for an injunction as well as a criminal will have a criminal liability.
You want? Anyone? Okay. Thank you very much.
Thank you so much.
Kindly join for a cup of tea.
Yeah, sure,
We'll take
sir, it's
your
a pleasure.
autograph.
Okay.
And next page your message.
Yes, yes.
Here it is the autograph. Here
Okay.
This is the wine.
I'll just take care.
Yeah, please. Continue. Next page your message. Here, last. This is the last.
Oh, okay.
Friends, kindly join for a cup of tea in the canteen. नहीं, उसके बारे में ज़्यादा डिस्कस मत करो, आपको प्रॉब्लम होगी।
Thank you. Thank you.
Again, we better you read yourself. More clarity will get.
Yes.
Please.
The Friday group today is an institution of alternative legal education. I compliment the team for the effort, especially Seshu sir. Wishing all the very best. Pragyan. Thank you so much. Thank you so